Independent contractor versus employee, and tax versus labor law. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. 36% of the United States workforce are independent contractors as of March 2024. What happens when a worker classified as an independent contractor is reclassified as an employee? What risks and laws do employees and hiring managers need to keep in mind? ACTEC Fellow Lee Stoutberg of Cincinnati, Ohio, joins us today to discuss the new Fair Labor Standards Act six-factor test versus the IRS and ERISA standards for classifying independent contractors and employees. Welcome, Lee.
Thank you, Travis. I appreciate the opportunity to be on this podcast. The Fair Labor Standards Act, or FLSA, is a federal law that establishes minimum wage, overtime pay, and child labor standards. On March 11, 2024, the Department of Labor published a final rule revising the DOL's guidance on what constitutes an independent contractor versus an employee. In the next few minutes, I will discuss the intersection of the FLSA's six-factor test, state and federal characterization, and touch on ERISA characterizations of employees versus independent contractors. Before doing so, let's consider some of the things that can go wrong if a worker is mischaracterized as an independent contractor. FLSA minimum wage and overtime. Unless an exemption applies, FLSA requires that workers classified as employees be paid minimum wage, currently $7.25, and overtime at not less than time and one-half for all hours worked over 40 hours. Also, misclassifying workers can expose employers to class action lawsuits. For example, in 2015, FedEx settled a class action lawsuit for $228 million after the Ninth Circuit found in the case Alexander v. FedEx that FedEx had mistakenly classified 2,300 truck drivers as independent contractors. And also, there's employer liability for payroll taxes, Social Security, and Medicare taxes. The IRS imposes a failure to deposit penalty ranging from 2 to 10% of the unpaid deposit with interest. There are back payments to workers for missed benefits like 401k, healthcare, equity compensation, paid time off, and family and medical leave. Failure to keep I-9s. Employer must complete and retain I-9 documentation with respect to all workers who are classified as employees for as long as the employee continues to work for the employer and for some time thereafter. A failure to complete and retain I-9 documentation for misclassified employees may lead to civil fines for the employer. And at the worker level, there is a denial of trade or business deductions. So, it is important to get the right classification of a worker as an employee versus an independent contractor, getting this right. Now let's step back and think about history a bit. In 1947, the Supreme Court looked at the case U.S. v. Silk. In this case, the court employed an economic reality test to hold that coal uploaders were employees. In determining whether these particular workers were independent contractors or employees within the meaning of the Social Security Act, the court applied the same rules as the National Labor Relations Act in Labor Board v. Hearst publications. In Silk, the U.S. Supreme Court noted that coal uploaders had no opportunity to gain or lose except from the work of their hands and simple picks and shovels that the workers provided. This economic reality test is basically the same as what has been used to effectuate the FLSA. Now let's get to this new FLSA six-factor test. The first factor, factor number 1, opportunity for profit or loss based on managerial skill. Basically, this factor looks at whether the worker can do things like negotiate pay, accept or decline jobs, choose the order in which the work is performed, and hire others. Factor number 2, investments by the worker and potential employer. If the investment is minor, this is an indication of an employee. Factor number 3, degree of permanence and work relationship. Is the work relationship continuous or exclusive? This would indicate an employee. Factor number 4, nature and degree of control. Can the worker set their own schedule? Is the work supervised by others? Is the work limited in the work he or she can do for others? Factor number 5, extent to which the work is performed is an integral part of the potential employer's business. Is the work critical, necessary, or central to the potential employer's principal business? For example, a large farm grows tomatoes that it sells to distributors. The farm pays workers to pick the tomatoes during the harvest season. Because a necessary part of the tomato farm is picking the tomatoes, the tomato pickers are integral to the company's business. These facts indicate status under the integral factor. Factor number 6, skill and initiative. Does the worker use specialized skills, and do these skills contribute to a business-like initiative? This factor indicates employee status if the worker does not use specialized skills in performing the work, or where the worker is dependent on training from the potential employer to perform the work. It is not only the technical skills, but also the use of the skills in connection with a business-like initiative. For example, a welder who markets specialized skills for multiple customers has a characteristic of an independent contractor. Okay, so now that we have this new 6-factor FLSA test down, let's think about the IRS rules on characterizing employers versus independent contractors. The FLSA and IRS can arrive at different conclusions as to what is an employee or an independent contractor. The Department of Labor's FAQs specifically state that the IRS applies its own test based on a common law test. The economic reality 6-factor test is used by the FLSA is broader because as a matter of economic reality, the worker is economically dependent on an employer for work. In Rev Rule 87-41, the IRS put forward 20 factors that it identified as indicating whether sufficient control is established to represent an employer-employee relationship. These factors included level of instruction, amount of training, degree of business integration, extent of assistance, continuity of relationships, flexibility of schedules, demands for full-time week, need for on-site services, sequence of work, requirements for reports, and so on. The IRS has acknowledged that these are not the only factors that are important. The IRS divides these types of factors into 3 categories of evidence. 1, behavioral control, 2, financial control, and 3, relationships of the parties. While these evidence categories, some of the old evidence factors have been prioritized, with certain factors being of lesser importance. ERISA has its own common law employee test. In Nationwide v. Darden, the Supreme Court adopted a common law test using general agency principles for determining who qualifies as an employee under ERISA, considering 13 factors. Hiring parties' right to control the manner and by means by which work is done, skill of the worker are 2 of these 13 factors. Does this sound familiar? As with similar tests, all of the incidents of the relationship must be assessed and weighed, with no factor being decisive. The commonalities among the FLSA new 6-factor test, the IRS 20-factor test, and the ERISA common law test include workers' opportunity for and realization of profits and losses, workers' investment in facilities and equipment, a continuing permanent relationship between the worker and the employer, integration of the worker's services to the activities of the company, nature and degree of control. These areas of overlap can be especially important to consider when analyzing whether to classify a worker as an employee or independent contractor. Where do these tests diverge? The answer to this question may have more to do with how the factors are weighed and interpreted than with the factors themselves. The FLSA definition of employment, suffer, or permit to work is recognized as potentially encompassing a broader group of workers than those who might qualify as employees under traditional agency or common law tests. An interpretation that favors finding employee status may be more appropriate when applying the FLSA test. Per the Department of Labor, economic dependence rather than control is the ultimate inquiry for purposes of the FLSA. Is a worker as a matter of economic reality and business for themselves? Although classification for FLSA tax and benefits purposes should be independent considerations, as a practical matter, reclassification under the FLSA may prompt reclassification analysis for other purposes as well. Employers proactively looking to properly classify workers for FLSA purposes may voluntarily choose to treat more workers as employees for all purposes. Travis?
Thank you, Lee, for discussing with us the distinctions in labor and tax law when classifying independent contractors and employees.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.